TDLR believes that safety is everybody's business. In case of severe weather or an emergency, remain calm and follow staff instructions. In the event of an evacuation, please use the marked exits and meet at the canopies near Cameron Road Church of Christ, located to the east of the Twin Towers. Upon exiting the building, check in with a TDLR safety officer who will be wearing a yellow vest. For additional safety tips, please pick up a brochure located at the sign-in table.
Hello, and welcome to a brief presentation about meetings of the Texas Commission of Licensing and Regulation. My name is Mary Winston.
And I'm Ken Sharp. Today we're going to explain how you can participate in the Commission meeting when the Commission makes a final decision for your case. You may have had a hearing in your case before a state administrative law judge. The judge issued a proposal for decision and sent the proposal to the Texas Commission of Licensing and Regulation to make their final decision.
First, let's talk about some basic information. There are times when the Department of Licensing and Regulation recommends an action to be taken against the licensee. It might be an administrative penalty or a license suspension or revocation against a person or company who holds a license issued by TDLR. TDLR can take unlicensed activity action against a person or company who works in an industry that requires a license, but the person or company doesn't have one. Also, TDLR is authorized under certain circumstances to deny an application for a license or license renewal.
In any of those circumstances, the person or company involved can ask for an administrative hearing to contest TDLR's proposed action. When that happens, the cases are called contested cases.
During the meeting, you may hear the commissioners talk about an ALJ. ALJ stands for Administrative Law Judge. The Administrative Law Judge has to follow and enforce certain rules of procedure in contested case hearings. These rules tell the judge what evidence must be admitted in the hearing and what evidence must be excluded or left out. This is important because if evidence is admitted, the ALJ may consider it when making a proposal for a decision. If the evidence is not admitted, the ALJ cannot consider it.
I think I know a better way to explain this. Think of this basket as what the judge considers when making a proposal for decision. The ALJ determines what evidence to admit and consider. The evidence might be documents.
Like these?
Like these. These will be admitted. They might be photographs or the testimony of witnesses. Admitted. If the ALJ admits the evidence at the hearing, the evidence goes into the basket and becomes part of the record. But if the judge excludes the evidence, it stays out of the basket and the judge cannot consider it when writing the proposal for decision. So, if the evidence was not admitted and the judge did not consider it, then the commission is not allowed to hear it or consider it.
As you can see, it is important to plan your presentation carefully to avoid having a TDLR lawyer or the commission chair interrupt to remind you that it was not admitted as evidence at the hearing. Therefore, you cannot discuss it at the commission meeting.
We hope this video helps you plan how you can participate in a meeting of the Texas Commission of Licensing and Regulation.
And remember, if you have any questions, you can call TDLR for assistance. While the staff at TDLR cannot give you any legal advice, they can answer basic questions about procedures and what happens at commission meetings.
Thank you for watching.
My name is Mary Winston. Today we're going to explain the public comment process for commission meetings.
And I'm Ken Sharp. We'll also explain the rules that you and the commission must follow during this process.
Members of the public may come to commission meetings to voice their opinions about matters under the commission's authority. This is the public comment part of the meeting. This is an opportunity for members of the public to have their voice heard regarding a subject that is not included on the meeting's agenda.
Now, as you might imagine, it would get confusing if everyone talked and the Commission didn't know who they were or why they were there. The Commission has a few rules to help make this an orderly process and to give everyone who wants to make a public comment a chance to speak.
To make a public comment, you must first complete a public comment form. You'll find these forms on the table by the door when you first walk into the Commission meeting room. Fill out the form completely, and when you finish, give it to the Commission's administrative assistant so she can add your name to the list of speakers for the public comment part of the meeting.
The second rule is that you must limit your comments to 3 minutes or less. 3 minutes can be a very long time if you're nervous.
Yes, it can, but it goes by quickly. That's why it's very important to plan your comments carefully so you can make your point in the short amount of time available to you.
An important thing to remember is that you may not comment on any case the Commission must decide during the meeting.
That's exactly right. The Commission does not want to ignore you or your opinions, but because of the pending case, the Commissioners might have to interrupt you and stop you from making those comments. That could be embarrassing, but more importantly, you will have wasted your time. The public comment portion of the agenda is for the Commission to hear what the public has to say about issues that are not specifically listed on the agenda. The public comment period does not include debate about the issues. If the topic you want to talk about is already on the agenda, then you have to wait until the Commission gets to that agenda item. You won't be allowed to comment on that topic during the public comment part of the meeting. Public comments are only for topics that are not on the agenda.
If you have a case pending before the Commission, you'll get an opportunity to talk to the Commission about your case when it comes up on the agenda. For that reason, you will not be allowed to talk to the Commission about your case in the public comment part of the meeting. The Commission will hear your case when it has to decide your case and when the Commissioners have your case file in front of them.
So those are the basic rules about making public comments at a Commission meeting. You must fill out a public comment form.
You only have 3 minutes to make all of your comments.
You may not comment on any case the Commission has to decide that day.
Any comments about a topic that is listed on the agenda must wait until the Commission takes up that agenda item.
If you have a case pending before the Commission, comments about your own case will have to wait until the Commission actually considers your case.
TDLR Commissioners are good listeners and will consider everything you say, but keep in mind that they are not allowed to respond to your public comments. That's because the Commission is only allowed to talk about things that are on the agenda. That way everyone, Commissioners and the public alike, will know how to plan for each meeting.
We hope you find this information useful as you plan to make a public comment at the meeting of the Texas Commission of Licensing and Regulation.
And remember, if you ever have any questions, you can always call TDLR for assistance. While the staff at TDLR cannot give you any legal advice, they can answer basic questions about procedures at Commission meetings, like offering public comments.
Thank you for watching.
Thank you for joining us. I'm Ken Sharp, and today we're talking about motions for rehearing.
And I'm Mary Winston. You may be asking yourself, what exactly is a motion for rehearing, and why would I want to file one? Or maybe you already filed one, but still aren't exactly sure what comes next.
A motion for rehearing is actually just a written request you can send to TDLR to ask the Commission to take another look at your case if you believe there was a legal error or mistake in the final decision or order in your case. The Commission can give you a rehearing if there was a substantial legal error in the decision or order and that error unfairly affected your rights.
For example, there might have been a mistake and how the law was applied in your case, or there may have been insufficient notice of the allegations against you.
However, the law does not allow the Commission to give you a new hearing just because you disagree with the decision. A motion for rehearing must be based on a legal error. It is not an opportunity to re-argue your case because you are unhappy with the decision.
The next question is, when and how do you file a motion for rehearing? The letter that came with your decision or order explains how to file the motion. First, you should carefully read those instructions. As we said before, your request must explain the legal error, the mistake of law you believe the department or commission made when it issued the decision or order against you. Also, the motion must be sent to TDLR in writing. Either a letter or an email is fine. Finally, the department must receive your motion within 25 days of the date that the order was signed. If it is not received in time, the Commission cannot consider your motion for rehearing.
Your motion will be reviewed by the Department's General Counsel Division. If the General Counsel determines the Commission can consider your motion, they will contact you and add your motion to the agenda of an upcoming Commission meeting in Austin.
You are not required to attend the meeting. Some people don't come. Some people watch the meeting on the TDLR website. However, if you file a motion for rehearing, we would encourage you and your attorney, if you decide to hire one, to attend the meeting, because when the Commission considers your motion, they might have a question that only you can answer.
So if I filed a motion for rehearing, what can I or my attorney talk about at the Commission meeting when the Commission considers my motion?
Once again, at the meeting, you may only discuss errors of law that you listed in your written motion for rehearing, and the only errors the Commission may consider are those legal errors that affected your right to a fair hearing. The Commission Chair will let you know if a particular issue is not appropriate for the Commissioners to consider. The Commission meeting is not a place to attempt to settle the matter, lower the fine, or restate or re-argue facts admitted into evidence if you had a previous hearing. Remember, a rehearing may be granted only if the Commissioners believe there was an error of law.
Well, what happens if you don't want a rehearing but just want to appeal your case right away to district court? How do you do that?
You can't. The law does not allow you to skip this process and appeal your case directly to the district court. The law requires you to first request a rehearing, like we've talked about here. If your motion for rehearing is denied, then you may appeal your case to the district court.
And speaking of appeals, if you appeal a decision of the Commission, that appeal must be filed with the district court in Travis County within 30 days from the date your motion for rehearing was denied. But appeals are complex legal matters, and you might want to talk to a lawyer if you are thinking about appealing a decision of the Commission.
It's always important to remember any person involved in a legal proceeding should talk to an attorney about legal rights and obligations. The legal proceedings before the Commission of Licensing and Regulation can be very complicated, and they certainly can affect your legal rights. TDLR staff may be able to answer questions about the procedures of the Commission meetings and the motions for rehearing. They cannot, however, give you legal advice.
We hope you found this information helpful. Thank you for joining us today. We'll see you at the Commission meeting.